government also plays a role and the judiciary also plays a role in the selection of judges. That means they jointly decide the selection of judges. Then they said that there is a possibility and a fear of give and take happening between the government and the judiciary, which is also not good for the independence of the judiciary. So they said that government should be totally removed. The only power that the government should have is to send the name back once. Thereafter, if it is unanimously reiterated by the collegium, then the government has to appoint that judge. Because there should not be any give and take between the government and the judiciary regarding appointment of judges. Now, and the basis for that was that the government is the main litigant in the judiciary or major litigant in the judiciary. Government has a stake in so many cases, especially cases involving protection of fundamental rights of citizens. And therefore, being one of the main stakeholders, it should not play any significant role or any role in the selection of judges who are going to be deciding these disputes which involve the government as a major party. Same thing I would suggest, my lord, so far as Election Commission is concerned. Of course, my default suggestion would be to follow what the Law Commission has said. That is, Prime Minister, Leader of Opposition, Chief Justice. But my first suggestion in my respectful submission is both the Prime Minister and the Leader of Opposition being heading political parties which are key players in the election process, ideally should not have a say in the selection of election commissioners, because election commission is the body which is going to decide not only disputes between the government and the opposition, etc., but is going to play such a critical role where the interests of the ruling party and the opposition are directly involved. Therefore, in my respectful submission, my lord, the selection should be by a body which is totally neutral. So such a body could be the Collegium of the Supreme Court. This is one possibility. The other possibility is that you say Chief Justice of India. You can add the present Chief Election Commissioner, because outgoing chief or the existing, if a selection of a member of the Election Commission, then the present Chief Election Commissioner. You can add perhaps Chairman of Human Rights Commission or somebody like that. You can add perhaps, I am not saying, my lord, what the situation is today. I am saying that ideally it should be, the selection should be in the hands of a body which is totally neutral. And though today, because the Election Commission is being appointed by the government, today the Comptroller and Auditor General is also being appointed by the government alone. Yet both Election Commission and CAG at least have functional independence. That means they cannot be removed by the government at their own sweet will. So in my respectful submission, there are these two kinds of bodies which will be totally neutral. One is the Collegium of the Supreme Court, which is the same collegium which selects judges. No, because it has to be a neutral body. What I am respectfully submitting is, my lord, the recommendations.
Keep one thing in mind.
Yes, sir.
And we can share our experience.
Yes, yes.
Wherever there is a human discretion,
yes,
element is there, discretion, yes, element. By and large, our experience also shows.
Yes.
Now, the only thing which we visualize from you is how this human element discretion,
yes,
available can be minimized. That only reflects your transparency. Because the discretion exercise, you have to keep the faith over the people who are manning. Ultimately, like we people in our judiciary, we take action against our judicial officers, and the same very judges, who are party to those minutes and who have reported their signatory to take action against him tomorrow sit in the judicial side and set aside the orders. Transparency is there. But still human element is there.
Your Lordship is right. That
and once we come out with the doctrine of necessity, somewhere down the line we have to show our trust over the persons who are manning the posts, and this discretion has to be exercised.
So, my lord, here there is no doctrine of necessity in the present system because the selection is totally by the government, only by the government. Nobody else plays any role, and the government is clearly a partisan player in the matter, in all the matters which the election commission decides, because the government is heading a political party which is a key player in the conduct of contesting elections. So therefore, on the principles laid down in the judges' appointment cases, as well as there have been several cases, my lord, where your lordship have directed, even for CBI director, it was this court's direction which eventually led to that. In Vineet Narayan, in police chiefs,
Yes.
yes, my lord.
This suggestion or submission is for the meant for the time during which there is no law made by Parliament, or you want to assume
Higher
court
status. I want, Lord, your lordship to lay down, because it should not be that tomorrow the Parliament makes a law. Suppose today the court directs that the selection of the election commission should be whatever. Suppose the court says, all right, Prime Minister, as the law commission has recommended, Prime Minister, leader of opposition, Chief Justice. And thereafter the government brings a law saying that no, it will be by the government. It will be a much worse situation than the NJSC Act. In the NJSC Act, the only role of the government was that in the selection committee there was a law minister and there were two other people, jurists, who would be selected between the government and the Chief Justice, etc. And that the secretariat would be housed in the law ministry.
But judge's appointment is the provision in the Constitution. There was a consultation which we have interpreted over a period of time.
Yes.
Here there is a specific mandate of the Constitution that Parliament by law can make this
Yes, Lord.
appointment. Now, how do you want us to confer on ourselves a jurisdiction to read down that part of Article 24(2)?
Yes, Lord.
In that regard, one more.
Yes.
See, 324(2), it says for appointment of the Chief Election Commissioner and other election commissions shall,
Yes.
subject to the provision of any law made in that behalf by the Parliament.
Yes.
And now in the unamended petition, you sought for issuance of a mandamus.
Yes.
Now, of course, you are seeking issuance of any appropriate direction. To what extent you are saying that this court can issue a specific direction to make a law in a particular manner?
No, we are not saying that make a law. We are.
In the light of the directions, the prayer, that is what we
I am
are.
not seeking that.
Of course, 324(2), it says
I am not asking for a law to be made, my lord.
prayer. That is why.
Maybe, my lord, that
Yes.
may have been.
Because the prayer, see, the amended prayer, of course, mandamus was the originally it was sought for. Now, in the amended petition, you sought for another prayer, issue an appropriate order or direction.
Yes.
To respond to implement an independent and transparent system.
So that's why, my lord, the original writ petition was not filed by me. When the petitioner came to me, I told him that you can't seek a direction to Parliament to make a law. So therefore, my lord, I sought permission to amend the petition. Permission was
instead of that, now you are using the expression implement.
No, we are saying respondents to issue a writ, order or direction to the respondents to implement an independent and transparent system for appointment of members on the election commission on the lines recommended by these various commissions. 5 commissions which went into it. But I am now today, my lord, in my oral submissions going one step further. I am saying that these commissions recommended a selection committee consisting broadly Prime Minister, Leader of Opposition, all of them say. In addition, there is some difference. Some of them say Chief Justice, some of them say Speaker, etc. I am going one step further in line with the NJSC judgment. The NJSC judgment says that, look, this system where the main stakeholders also play a role in selection of judges, though the dominant people may be independent, but if the main stakeholders also play a role, then that will be amenable to give and take, which is not good for the independence of the judiciary. I am saying the same thing with regard to the Election Commission. Today, my lord, Election Commission, the main political parties are the main stakeholders before the Election Commission. They are the main stakeholders. And therefore, in my respectful submission, the system should be selection by a totally neutral body. Now, what that neutral body could be, I have said. One option is the Collegium of the Supreme Court, just as they select judges. The second option is that you can have 3 senior judges of the Supreme Court along with, let's say, the existing Chief Election Commissioner, the Chairman of NHRC or the CAG. I am mentioning these authorities because at least they enjoy functional independence. Tomorrow, my lord, after your lordship's direction in this case, assuming that we succeed, the election commissioners will also enjoy independence by way of selection. And once that happens, then of course, my lord, the Chief Election Commissioner can certainly be in the selection committee, or the outgoing Chief Election Commissioner, if this selection is of the Chief Election Commissioner, certainly be on the. So therefore, my lord, this would be, in my respectful submission, a neutral body where the main stakeholders do not play any significant role. And that will ensure. The argument is this, my lord. Free and fair elections is a basic feature of the Constitution. Democracy, basic feature of the Constitution. Now, if it is felt by this court, which has plenary powers under 142, that in order to ensure the independence of the Election Commission, it needs to be selected by some independent body, then, my lord, this court has in so many cases given such directions. Prakash Singh, in the case of CBI reforms, Vineet Narayan, in the case of passed by Parliament, tomorrow they can pass a law saying that government will enjoy complete control over the selection. But that should not override, because these directions are being given to implement the basic structure of the Constitution, to implement the basic feature of the Constitution, which is free and fair elections. Yes. Now, my lord, so I have given the end of what I want. Now, Lord, let me take your Lordship through the material. So, first, what happened in the Constituent Assembly? So, Lord, Dr. Ambedkar, at page 2 of the note, your Lordship can just take the note because I've quoted almost.
You've seen it actually. You've seen your line of argument in the material.
Yes.
So Bangla, Saxena, the exchange between them,
Yes.
and then what are Dr. Ambedkar. So you've seen that.
So should I read it, or I don't know whether.
You've seen it. Go ahead in your room.
That's very good. So,
go ahead.
yes, sir. But page 2 of the note below, Dr. Ambedkar presented an amendment in Article 289(10) of the Constitution, of the proposed Constitution. The amendment vis-a-vis the appointment of Election Commissioner was as follows. The Election Commission shall consist of the Chief Election Commissioner and such other election commissioners, if any, as the President may from time to time appoint, and when other election commissioner is so appointed, Chief Election Commissioner shall act as Chairman of the Commission. Dr. Ambedkar, while presenting the amendment, said the House will remember that in a very early stage of the proceedings before the Constituent Assembly, a committee was appointed to deal with what are called fundamental rights. The committee made a report that it should be recognized that the independence of the elections and the avoidance of any interference by the executive in the elections to the legislature should be regarded as a fundamental right and provided for in the chapter dealing with fundamental rights. When the matter came up before the House, it was the wish of the House that while there was no objection with regard to this matter as of fundamental importance, it should be provided for in some other part of the Constitution and not in the chapter dealing with fundamental rights. But the House affirmed without any kind of dissent that in the interests of purity and freedom of elections to the legislative bodies, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. In pursuance of the decision of the House, the drafting committee removed this question from the category of fundamental rights and put it in a separate part containing articles 289, 290 and so on. Therefore, so far as the fundamental question is concerned that the election machinery should be outside the control of the government, there has been no dispute. What Article 289 does is to carry out, this is the provision contained in subclause 1. Then, my lord, Dr. Shibban Lal Saxena raised reservations about the appointment of the Election Commission by the President and proposed that Election Commission should be appointed by 2/3 majority of both houses so that the Commission enjoys the confidence of the House and not only of one party. That is at page 33-34 of the compilation. Dr. Ambedkar addressed the criticism of Mr. Saxena and conceded that his provision quote, because as I said, it is going to be one of your greatest headaches, and as a via media, it was thought that if this assembly would give or enact what is called an instrument of instructions to the President and provide therein some machinery, which it would be obligatory on the President to consult before making any appointment, I think the difficulties which are felt as resulting from the American Constitution may be obviated and the advantage which is contained therein may be secured. At this stage, it is impossible for me to see or anticipate what attitude this House will take when the particular draft instructions come before this House. If the House rejects the proposal of the drafting committee that there should be an instrument of instructions to the President which might include, among other things, a provision with regard to the making of appointments, this problem would then be solved by that method. But as I said, it is quite difficult for me to anticipate what may happen. And therefore, my lord, the final provision which came was as it presently stands, that subject to any law made by Parliament. Unfortunately, no law was ever made by Parliament. Then, my lord, I have mentioned the powers of the Election Commission, that they enjoy vast powers of all kinds. And of course, this court has also held in Shamsher Singh onwards that Election Commission's powers are vast. They have complete powers to control free and fair elections, to ensure that elections on all matters. The aforementioned provisions show that the power of the Election Commission extends to resolving disputes between various parties or adjudicating on a complaint made by one party against the other party. So the parties are stakeholders. The Election Commission play even a quasi-judicial role or a judicial role in determining disputes between political parties, which are headed by the Prime Minister, Leader of Opposition, etc. Then, my Lord, I have not mentioned it, Your Lordship may just note that there was a Citizens Commission, here Your Lordship may note, headed by Justice Lokur, which is at page 999 of the compilation, where the Citizens Commission, this is of last year only, they have mentioned that the Election Commission unfortunately is no longer functioning very independently. I don't want to get into that. I don't need to get into that. I'm just saying, my Lord, if the situation had been what was prevailing when in the time of Mr. Session or some years thereafter, this matter would not have assumed the kind of importance that it has today. Today, unfortunately, because there are, I'm not even getting into the question whether the Election Commission has been behaving independently or not, but certainly a lot of people, a lot of very respectable people have voiced apprehensions on this, that the Election Commission is no longer behaving very independently. So therefore, dates are being announced, that the dates for elections are being announced, which are known and announced by the government or the party in power prior to the Election Commission announcing the dates and so on. And all kinds of things have been happening. But it is not necessary for this court to go into that. It's enough for this court to say that, look, Election Commission's independence must be secured. At all costs, the independence of the Election Commission must be secured. And in order to secure the independence of the Election Commission, it is not enough for the Election Commission to have functional independence by way of government not having disciplinary control over them. It is also necessary that the selection of the Election Commission is by an independent body or by a neutral body, or certainly not controlled just by the government alone. So, because government is certainly one of the stakeholders, various commissions which I have mentioned.
Goswami Commission.
Yes, first is I have mentioned the Law Commission. They recommended, and this is at page 266.
Goswami Commission precedes the Law Commission.
Yes, long time back. Goswami Commission is.
And the 255th Law Commission report refers to the Goswami Commission.
Yes.
And it has also made its recommendation.
Yes.
In 2015. You are conscious of that.
Yes. So 2015 is the last report of among these commissions, that is of the Law Commission. And that's at page 266 of the compilation. I am not reading that, but broadly, my Lord, what they said was
the need for an
independent selection committee, and they felt in their wisdom at that time that that may be in a way, my Lord, that is coming. But, as I said, my Lord, both the Prime Minister and the Leader of Opposition are stakeholders before the Election Commission. And if you apply the principle which was enunciated in the NJSC case, they said that the stakeholders should not have a say, because they be give and take and so on. So therefore, stakeholders should not have a say. They, of course, they have the right to send the name back if they feel that there is some problem with some particular appointment. But thereafter, if it is unanimously reiterated, they have no option but to appoint. It's another matter that today even that is not being followed.
The argument could be raised that in the case of appointment of judges, part of the reasoning which made with the court was that judges know who are the most suitable persons. At least that was a theory. They know whether with Chief Justice, they know the collegium system works on that basis. But here, when you're selecting, mostly it will be IAS officers, and the judges of the Supreme Court perhaps lay claim to know about the credentials, competence, character of the individual judges. I mean, of the individuals concerned.
In my respectful submission, my lord, yes.
There might be that issue.
Yes, no, I know that there is a slight difference, not identical. But this court, my lord, deals with every kind of case, including such cases like appointment of election commissioners and so on. All these matters come to this court. Ultimately, my lord, what has to be done? Somebody has to apply his mind to see, all right, what are the needs for having an election commissioner? What is the role that the election commission will be playing? And therefore, what kind of qualifications or what kind of things are required or recommended for such people as being election commissioners? And therefore, who should be selected? True that there may be a slight difference between the knowledge that judges have of judges versus the knowledge that judges have of people who are being selected for election commissioners. There may be a difference, slight difference there. But it is outweighed by the overwhelming advantage of their being politically neutral. Judges are at least politically neutral to the question. They are not stakeholders in elections. So therefore, in my respectful submission, my lord, the neutrality of the selection committee will outweigh. Of course, they can receive whatever recommendations, they can receive recommendations from the government, from the leader